The Brazilian government is committed in transforming the business environment in Brazil, improving regulatory conditions for entrepreneurs and companies that drive our economy. Today we're going to talk about the important changes for the corporations brought by both the legal framework for startups and by Law 14/1985. Stay with us. One of the government's main platforms is to reduce the so-called Brazil cost, which includes mechanisms to accelerate the incorporation of companies in the country, reduce bureaucracy for entrepreneurs, as well as create a specific regulatory framework for technology companies in an attempt to promote the creation and development of these companies. And in the context of these regulations, a series of provisions were also introduced, modifying the operational rules for some corporate types, in particular for joint stock companies. These changes aim to reduce the maintenance cost of such companies and tend to lead to the adoption of this corporate type also by small and medium-sized companies. Some significant changes have been implemented when it comes to the management of corporations. Firstly, the joint stock companies are now allowed to appoint a single statutory officer. In addition, officers residing and domiciled abroad may now be appointed, equaling the treatment already given to members of the board of directors. It is noteworthy that the appointment of an executive residing and domiciled abroad is also subject to the appointment of an attorney-in-fact residing in Brazil, with powers to receive services of law for a period of at least 3 years after the end of his or her term of office. It is important to highlight that the limited liability companies will also benefit from such modification and will be able to appoint administrators residing abroad. Although this change meets a recurring demand from foreign investors, some fiscal and practical aspects must still be addressed in order to avoid any difficulties in the day-by-day administration of the company by officers residing abroad. As regards publicly traded companies, two relevant modifications have been implemented as a way to protect the minority shareholders of such companies. The election of independent directors is now mandatory, and the chairman of the board of directors and the company's main executive cannot be the same person, something that is already mandatory for those companies traded under the listing segment of the Brazilian Stock Exchange called Novo Mercado. This specific rule shall come into force in 1 year. Other aspects that were simplified and aims at reducing the bureaucracy for the companies relates to mandatory publications and management of the company's books and documents. Based on such regulation, privately held companies with annual gross revenues of up to 78 million reais are authorized to make all publications required under the corporation's law by electronic means. This will represent huge savings for the companies, especially for smaller ones. In addition to that, closed corporations are now entitled to replace certain physical corporate books for electronic registers. Perhaps the greatest change brought by these recent regulations was the adoption of the dual-class stock structure by Brazilian corporations law. By means of Law 14/1985, it became possible to issue one or more classes of common shares with weighted voting rights, granting the holders of these shares with more than one vote per share in the shareholders' meetings. This mechanism is widely used in other jurisdictions and promotes an imbalance between the shareholders' financial participation in the company and its political rights. To avoid abuses, the Brazilian legislature modulated the use of such mechanism and established a series of limitations to protect the position of other shareholders. The limitations can be seen in our website or otherwise in the link included in the description of this video. The adoption of dual-class structures can be considered an advance for the Brazilian stock market, providing companies with new tools and more variations to accommodate the interests of shareholders with different profiles. But it will also require greater caution and attention when it comes to analyzing the acts performed by holders of such classes of shares. In this context, the Brazilian Stock Exchange Commission will certainly have a proeminent role, since the decisions and understandings of the agency will certainly be the grounds for future court decisions. As we saw in this video, the changes implemented by the Startups Legal Framework and by Law 14/1985 significantly modified the Brazilian corporate environment. The new rules simplify the administration and routine of the joint stock companies, as well as create new alternatives to accommodate the interests of various shareholders. Our corporate team can provide you with more information and assist you with these new rules. See you in the next video.